And welcome to today's webinar on the Data Use and Access Act 2025. Thank you all very much for joining us. My name is Kiran Chita and I'm a solicitor in the Commercial and Technology Group here at Field Seymour Parks. And I'm joined today by my colleague Harris Qureshi, who is also a solicitor here in the Commercial and Technology team. Before we get started today, I'm just going to run through a couple of quick housekeeping points. The webinar is being held remotely today, so please bear with us should we experience any technical difficulties. We will aim to resolve them as swiftly as possible. The webinar today is 30 minutes long. All attendees are on mute, but if you do have any questions, please do just pop them in the questions box that you should be able to see. And we will be doing a Q&A at the end of the webinar. We will aim to get through as many of the questions as we can, but of course, if there's anything that we can't cover, we will follow up by email afterwards. The webinar today is being recorded, and we will send the recording to all attendees after, as well as the slides. And there will also be a survey at the end of the webinar. So we would be really grateful if you could fill this out with any feedback that you have. We will also be covering today a select few changes and providing an overview, but of course if you would like us to go into further detail on any of these points, or if there are additional areas of the Act that you'd like covered, please do let us know in your feedback, and we will endeavour to do this. Okay, so today we will be looking at the Data Use and Access Act 2025, which represents a major reform to the UK's data protection landscape. So the agenda for today, we will look at the introduction of the Act itself, the timeline for the various changes that are going to come into play, and also what the Act tells us about the UK government's approach to data protection reform. We will then look at some of the key changes introduced by the Act, namely the introduction of a new lawful ground for processing personal data, that being recognised legitimate interests, purpose limitation, changes around automated decision-making and international transfers, as well as updates to DSARs, complaints procedures, and the structure just before we get started, I'd like to do a quick poll, if we have that. Yeah, so just so that we have an idea before we dive in, if you could let us know before today, how familiar were you with the Data Use and Access Act? Were you either very familiar, somewhat familiar? Had you heard of it, maybe heard of some of the key changes, but don't really know much about what they mean, or not familiar at all? So we will just give you a minute or two to answer the poll. And here we go. Okay, so the majority heard of it but don't know much. That is great, because hopefully today will be really helpful for you all, and we will, as I said, dive into some of these changes, give you a bit of an overview, so hopefully you're in the right place. And without further ado, I will now pass over to my colleague Harris to take us through the timeline for implementation, the new lawful ground for processing, and purpose limitation. So over to you, Harris.
Thank you, Kiran. Just in terms, before we go into the timeline and the provisions, just going to have a quick discussion regarding the UK government's approach to data protection. So this new legislation, the Data Use and Access Act, came into force on the 19th of June this year. So it essentially amends the GDPR, Data Protection Act, and the Privacy Electronic Communication Regulations. So that's known as PECR, which, if you don't know, governs electronic marketing, cookies, and tracking. Now, the key thing to note is the fundamental principles of data protection legislation are not changing. So requirements for controllers and processors, as those are set out in Article 28 in the GDPR, still remains the same. The Act has been introduced under 3 aims from the government. So it's to promote economic growth, support a modern digital government, and improve people's lives. So it's essentially looking to modernize data protection laws whilst preserving the standards and compatibility with EU. So moving on to the next slide on implementation. So while certain changes came into force on the 19th of June, i.e. changes to DSARs, which I'll be touching upon later on, most changes are coming from secondary legislation, so they're not applicable from day one. Most of this will be also supplemented by ICO guidance. The government's essentially explained that many of the provisions will be commenced by regulations in 4 main stages. Now, the first 2 stages have been introduced, includes, for example, the commencement of technical provisions, clarifying the legal framework, and most measures regarding digital verification services. The focus of this webinar will be mostly regarding some of the changes that are coming into play from stage 3 and stage 4. So stage 3 is approximately December this year. Main changes to part 5 of the Act. So we'll be focusing on this. This is except for section 103 on complaints by data subjects and provisions on information standards for health and adult social care in England. Now, stage 4's provisions that require a longer leading time, and this is expected in 2026. So, i.e. changes to the ICO's governance structures in part 6 of the Act, and that's something that we'll be touching upon later on. So now moving on to one of the main key changes that we'll be discussing today is recognise legitimate interest. So as you'll be aware, in order to lawfully process personal data under the UK GDPR, controllers must rely on 6 lawful grounds, with legitimate interest being a common one relied upon. Under this ground, it can be helpful for controllers to think of it as a 3-part test. So the test is sort of, for example, purpose. Is there a legitimate interest? Is processing necessary for that interest? And do the data subject rights interests override the controller's interests? Now, the new legislation essentially introduces a new legal basis for processing personal data, and that's known as recognised legitimate interest. Now, it amends Article 6 of the UK GDPR so that the requirement to undertake a legitimate interest assessment in relation to this basis doesn't apply. So it essentially doesn't require balancing tests at the outset. So please note, however, that processing must still be necessary and organizations must still maintain transparency to data subjects, as always under the accountability principle and the GDPR. Now, the list of recognized legitimate interests includes the following. So as you can see on the screen, it includes crime prevention, safeguarding vulnerable individuals, and responding to emergencies. Just to flag, this change is more relevant to organizations with relationships with public authorities. So for example, to facilitate compliance with requests from public authorities. So the changes have been introduced to reduce the admin burden, especially when organizations need to act fast in sensitive matters. The Act also explicitly provides 3 examples of processing activities that may qualify as legitimate interests. So that includes intragroup data sharing for admin purposes, direct marketing and processing to ensure network and information security, which will still require a legitimate interest assessment. The Secretary of State also has the power to amend the list of recognized legitimate interests. Moving on to the next slide. So this is focusing on purpose limitation. Now, the Act essentially restates the GDPR provisions on this, which is one of the data protection principles. Now, under the UK GDPR, this principle ensures data subjects have their personal data used for the explicit, specified, and legitimate purpose it was collected, and it shouldn't be processed for additional purposes which aren't compatible with the original ones. Now, Schedule 5 of the Act inserts Annex 2 into the UK GDPR. This includes a list to be considered in determining whether a new purpose for processing data is compatible with the original purpose. So it introduces a list of purposes in which further processing or data reused is deemed compatible without a separate compatibility assessment, which includes, for example, as you can see on the screen, disclosure for the purposes of archiving in the public interest, crime prevention, safeguarding of vulnerable individuals. Now, this amendment is intended to provide clarity and streamline processes to enable organizations to reuse personal information for those purposes without having to do a compatibility assessment or having to obtain renewed consent. Moving on to the next slide. Which my colleague Kiran will be discussing.
Thanks very much, Harris. So on to automated decision making. As you can see from the slide here, this sets out the change in the way that the legislation talks about automated decision making. So you can see previously under the UK GDPR, automated decision making is a decision based solely on automated processing, which produces legal effects concerning the individual or similarly significantly affects the individual. And as you can see, under the Data Use and Access Act, some clarification has been introduced as to what this means. So it's solely automated if there's no meaningful human involvement in the decision, and also a bit more clarity around what's the meaning of significant. And so, yeah, indeed, actually, you know, one of the most notable changes that's been introduced by the Act is the relaxation of rules around automated decision making. And I think this is something that has attracted a lot of attention. So the existing position under the UK GDPR, it's generally not possible to make a decision that produces legal effects if that decision is based solely on automated processing, unless there are very specific exceptions. Those exceptions being explicit consent from the data subject, the processing being necessary for the purposes of a contract between that person, and the organisation or the processing is permitted by UK law. The Data Use and Access Act reforms this existing framework and broadens the scope for automated decision making. Those previous restrictions have been modified such that organisations will be able to rely on any of the relevant lawful basis for processing if they want to carry out such automated decision making having a significant effect on the individual. That is, as long as the data involved is not special category personal data, and also the organisation must have the appropriate safeguards in place. I should also note that it does not apply to the new lawful basis of recognised legitimate interests. As mentioned, under the Act, there are similar restrictions with respect to the use of special category personal data in this regard. So again, not possible unless the data subject has provided their explicit consent, processing is necessary for the purposes of a contract, or the processing is authorised by law. And in respect of the second and third points that I just mentioned, the processing must also be necessary for reasons of substantial public interest, and there must be suitable measures to safeguard the data subject's rights in place. So similar restrictions remain with regard to special category personal data, but the Act does see a relaxation when it comes to non-special category personal data, provided that the relevant safeguards are in place. Those safeguards being that the organisation must provide the data subject with information about the decisions taken in relation to them, and must also enable the data subject to make representations about such decisions, to obtain human intervention from the data controller in relation to such decisions, and also enabling the data subject to contest such decisions. So the simplification of the requirements around automated decision making does mean that this can now be carried out in wider circumstances. And the introduction of these changes really are designed to provide more flexibility around the use of AI tools for organizations. And this change is seen to be in line with the general UK approach to AI regulation, which seeks to adopt a principles-based approach to facilitate innovation. And so this change, I think, will be welcomed by organizations, and to the extent that this means that, you know, automated decision making will be used where it wasn't already, organizations should ensure that the implementation of such decision making needs to be reviewed, and need to ensure that ensure transparency and ensure that those mechanisms are implemented for human review and for data subjects to challenge such decisions. Also, organizations will need to update privacy notices to explain you know, how data subjects' personal data is being used, to explain those automated decision-making processes and set out rights. And also where automated decision-making is being adopted, generally this, you know, consider whether this will require a data protection impact assessment to be carried out, or DPIA. The ICO has said that generally where any kind of processing involves AI, it would typically expect a DPIA to be carried out. So definitely something to bear in mind and consider if that is required. So now moving on to international data transfers. The Data Use and Access Act reforms the UK's approach to cross-border data transfers. We have seen the introduction of an adequacy test, which is now called a data protection test. And that test is that instead of requiring essential equivalence, the standard of protection provided must now be not materially lower than the standard of protection provided under the UK GDPR and Data Protection Act 2018. Ultimately, it's not yet clear how not materially lower is going to be different from essentially equivalent. Under the current regime, it will be up to the Commissioner to provide guidance on this point, and we'll see how it plays out. But the intention of the Act seems to appears to be to introduce a different, likely slightly lower standard for making international transfers under the UK GDPR than currently exists under the EU GDPR. But it does remain to be seen how much this will diverge from EU standards. This also means that adequacy can now be granted, as before, to entire jurisdictions, but also to specific sectors within a country, or based on specific international commitments, which again is a difference from the EU's centralised holistic approach. The Act also introduces a provision which codifies the Schrems doctrine and essentially sets out the requirement to carry a transfer impact assessment where there is no adequacy decision in place. The Act also introduces a new power for the UK government to recognise alternative transfer mechanisms beyond standard contractual clauses and binding corporate rules, which are currently in place. So this could see the recognition of sector-specific codes, certification schemes, or indeed the introduction of standard contractual clauses that automatically satisfy the requirements for appropriate safeguards, potentially removing the need for transfer risk assessments entirely. So I think, you know, that will be really interesting to see what happens, and hopefully will facilitate easier international transfers and smoother international transfers of data. So really, you know, the steps to take now, I think the key thing is to be monitoring ICO guidance for approved alternative mechanisms and guidance on how this standard of not materially lower will be applied and what this means. In time, as the approach becomes clearer, you know, this will potentially result in updating international transfer policies and contracts to ensure they reflect the new approach, the difference in the standard, and any new safeguards and mechanisms that are introduced, and also potentially reassessing existing transfer risk assessments using this new threshold. But the hope is that this will make things easier for organizations. I will now pass back to Harris to take us through the changes around DSARs.
Thank you, Kiran. So on DSARs, so the main provision to note that took effect immediately on royal assent was to the change to DSARs. So it's essentially a change to the scope of the search requirements for data controllers when they receive a DSAR. So, businesses are required to essentially now carry out reasonable proportionate searches when responding to DSARs. In addition, the 1-month response deadline may also be paused if the controller needs to seek further information from the requester, i.e. to verify the identity or clarify the request scope. So once the organization, although has the necessary information, this clock will still continue. So just to be clear, this essentially codifies the ICO's guidance. So it's a positive change as it's essentially enshrined in legislation now. So it's there to sort of provide more comfort to organizations with proportionality. And moving on to the next slide, complaints procedure that Kiran will discuss now.
Thanks very much, Harris. So the Data Use and Access Act also introduces a statutory right for data subjects to complain directly to data controllers, which is shifting some of the burden from the ICO to organizations themselves. The requirement is that organizations must give data subjects a clear way to make data protection complaints. And so this applies to any complaints, not just those in relation to data subject rights requests. This could be with respect to a data breach or how that individual's data was handled. The requirements are that the complaint needs to be acknowledged within 30 days of receipt and must be responded to without undue delay. This means that within an organization, it's important for employees to know what to do if they receive a complaint, given that the clock will be ticking. And this may mean changes to internal data protection handling procedures if an organization doesn't already provide for general complaints per se. The requirement is, the Act also introduces the requirement that controllers need to take appropriate steps to respond, which includes making inquiries with complainants and also keeping the complainant informed. And organizations must also tell the complainant the outcome of their complaint. As for how this will actually work in practice, the ICO did have an open consultation on draft complaints guidance for organizations. This closed on the 19th of October, and so hopefully, we will see the finalized guidance in due course. But the draft guidance does suggest a number of ways in which complaints can be made. Could be by live chat, electronically by way of a complaint form, by telephone, or an old school written complaint. The guidance suggests having a written complaints procedure in place, and that there will be, a number of ways that the complaints procedure can work, but really it will be a matter of working out what works best for your business. There's no standard form as of yet from the ICO, but it will be interesting to see what comes out from the consultation. And additionally, actions taken should be recorded by the organization, and each complaint should be reviewed so that lessons can be learned from any complaint received. The Act also provides the option for the ICO to require controllers to notify the ICO of the number of complaints. That's not a requirement at the moment, but it indicates that it could be a possibility. And so it is foreseeable that if there are increasing levels of complaints, then these regulations could become a reality. So the introduction of this mandatory complaints procedure means that the ICO will act as a second-tier complaints handler, essentially, as complaints can only be escalated to the ICO once the controller has responded to the data subject. And the ICO will only step in after organizations have had the chance to resolve issues themselves. This is intended to reduce the ICO's caseload and encourage resolution at source. And really, this is one of the changes, along with a few others, that sees a change in the way that the ICO is in the way that the ICO operates. So the Act introduces a number of changes to the ICO. If we can go to the next slide, please. So whilst the ICO remains the regulator, the Act updates the legal framework under which the ICO operates, modernising its governance and accountability. A quick overview of some of the changes, as I am conscious of time and do want to get to questions. So the Act introduces a new strategic framework for the ICO when carrying out its data protection functions. This includes a principal objective, which is to promote public trust and confidence in the processing of personal data, alongside the ICO's pre-existing duty to secure an appropriate level of protection for personal data. There's also several matters to which the ICO must have regard when undertaking its tasks, including the promotion of innovation and competition. I should also note that the ICO becomes the commissioner, but forgive me if I continue to say ICO, it's just habit, but something that we will need to get used to. And there's also a change in the structure. So the ICO is transitioning from a single commissioner model to a corporate board structure. And this means that the information commissioner will be supported by a statutory board, improving transparency and collective decision making. The ICO also gains new duties to issue guidance on areas such as recognized legitimate interests and automated decision making. This ensures that all statutory codes of practice issued by the Information Commissioner have the same legal effect and follow the same approvals process and review requirements. The Act also makes several changes to the process through which the ICO develops statutory codes, requiring consideration by a panel of experts, and for the ICO to undertake and publish impact assessments. There are also increased transparency requirements. 2 new reporting requirements are introduced, including an annual analysis of performance using KPIs and an annual report on regulatory actions. So overall, the Act gives the ICO clearer strategic direction, strengthens obligations and transparency, and also modernizes governance to reflect the breadth of issues in data protection regulation. So overall, from the changes that we have seen and highlighted today, the Data Use and Access Act marks a shift towards a risk-based and innovation-friendly data regime. But it also introduces various proactive steps that organizations must take to ensure transparency, accountability, and responsiveness. Being aware of the new legal basis for processing, recognized legitimate interests and purpose, and the impacts of purpose limitation. The automated decision-making changes means ensuring appropriate safeguards are in place if your organization starts to carry out automated decision-making, making sure those safeguards are in place, the transparency requirements. We would also say that the changes introduced around international transfers will be interesting, and it's important to continue to monitor how this evolves. And then when it comes to DSARs and complaints procedures, really ensuring that the appropriate procedures are in place and updating internal policies as required and arranging appropriate training for staff. Of course, if there is anything that we have mentioned today, or indeed anything else data protection related that you would like assistance with, or you have more questions about and would like to discuss, please do not hesitate to reach out to us. Thank you very much for attending. I hope that you all enjoyed the webinar, and I am conscious that it's past, but we will now open the floor for questions and hopefully be able to answer a couple of questions, and any that we don't get to, we will follow up with you by email. So So let's just see what we have got here. Okay, so we have a question on the complaints procedure asking whether are existing systems sufficient, or do we need a specific data protection complaints system? Okay, so yes, organizations can generally adapt their existing complaints procedure if you already have one, but you do have to ensure that it's suitable for handling data protection specific issues. For example, complaints about mishandling personal data, failing to respond to access requests, or keeping inaccurate requirements. And it does need to meet the new requirements under the Act. So, you know, the response times and the keeping the complainant informed, those obligations. So you can use an existing complaints procedure, but it must be clear that it can be used for data protection and is intended for, as well, as well as general complaints, also data protection specific issues. I hope that's helpful. And I think we have another one.
Just found seen a question, I'll read it out. It lists, if an activity isn't listed in the recognized interest annex, must we still use the normal legitimate interest ground? A quick simple answer would say, well, yes, if it's not listed in the annex, you'd still have to sort of go through the tests that you'd have to go through to rely on that ground, i.e., go through sort of purpose, if there's a legitimate interest, if the processing is necessary for that interest, and the balancing test, whether the data subject's rights and interests override the controller's interests. So essentially looking to carry out a legitimate interest assessment. Thank you.
Right. Okay, I'm conscious of time, so there are a couple of other questions, but we will follow up via email with those ones, and they will be answered. So thank you very much all for joining. I hope that was helpful and informative. Please do complete the feedback form. Please do let us know if there's any areas where you would like more information or other topics you would like us to cover. We are happy to do so. Thank you all very much.